Committee will come to order. The gentleman from Maryland is recognized for 5 minutes.
Thank you, Mr. Chairman. Good afternoon, General. How are you?
Very well, thank you.
Good. I want to point out 3 things that you've said so far today because I want to emphasize these for the committee going forward. One was you said, we will not back down, we will not be intimidated. And the other thing you said, too, was the way to not interfere with an investigation is to not investigate the investigation. Now, I thought that was particularly apropos here because this committee has been doing exactly the opposite. We've been, under the chairman's leadership, investigating prosecutors all over the country in the middle of criminal investigations and sometimes post-indictment, sometimes pre-indictment, I think in an effort, frankly, to derail the prosecutions in those cases. And I'll start with the one, this is the Alvin Bragg effort. The chairman and 2 other committee chairs sent a letter, I think 2 actually, to DA Bragg. At the time he was still investigating former President Trump for potential prosecution. And then after he was indicted, they raised the issue again. And the concern I had on that front was multiple. One was, one of the letters that the committee chair sent was demanding information that potentially would have violated state law in New York, similar to the federal grand jury secrecy laws that we have in some of the matters that you govern, if he had complied with what the committee had demanded. But more importantly, I thought it was pretty clear-cut that it was an effort to undermine and derail DA Bragg's investigation. There was a similar version of that with DA Willis. I know there have been a lot of calls.
Would the gentleman yield for just a second?
Not at this point, although I'd be willing to make your letters a part of the record at the end of the. DA Willis in Georgia faced similar calls. In fact, there are a number of prosecutors across the country, frequently they're in blue jurisdictions, cities, and red states, where they face pressure from usually state officials to curtail the way they're doing investigations. And in some instances, the state AGs have stripped them of their authority, even though they've been duly elected by citizens in those states. And then with respect to the Jack Smith investigations, at the beginning of the hearing, the chairman brought up Trump did everything DOJ asked him to do. Now, this is with respect to the search warrant. And I was appalled at what was said. Frankly, as the record bears out, both in the indictment and frequently in statements made by Mr. Trump himself, there were multiple efforts by the Department of Justice to reach out through the attorneys that represented Mr. Trump and have him comply and turn over documents. He refused to do so. In fact, the allegations are he, in fact, moved documents and tried to hide them so the Department of Justice couldn't get them. And that also led to the issue where Mr. Trump's lawyers ended up having to provide information and testimony about what had happened, which is highly unusual, but this scenario is highly unusual. And we know that's the case because former Vice President Pence and current President Biden had similar issues, but they complied with the request by the Department of Justice, turned over the documents, and so you didn't need a search warrant. But the news here is, I guess, if you don't comply with subpoenas from the Department of Justice, they will go get the information. They'll get a search warrant and go get it. And I know that because I've seen that in multiple cases in my career. There's no surprise, and there's certainly no 2 tiers of justice with respect to what was done in that instance. In fact, the fact that they took so long to do it, I think, is based entirely on the fact that he had been president. And then with respect to Mr. Weiss, because this is the most recent version, and I get why they're doing it. They want to try and build a case to impeach President Biden. The Weiss angle seems to be one of the ways they're trying to do that. But as Congressman Buck said, everything the department did with respect to Mr. Weiss was correct. Because if the Biden administration had removed him when it came into power, there would have been howls from the Republican side that you were derailing the investigation because Weiss was already on it, and if you brought in somebody new, they'd have to start over again. And in fact, the Senate Republicans, as you testified earlier, sought your assurances that you would let him continue going forward, and as you've testified today, you've done exactly that. So I want to be clear. I know the committee's talking about bringing Mr. Weiss into testimony. They brought all these other people in to testify who were part of an active investigation. But it is a horrible precedent to be bringing in prosecutors in the middle of an investigation that's about to go to trial, that's already been indicted. That's not the way this committee should be doing business. We should allow prosecutors to move forward. If we got questions after the fact, we can raise them, as you pointed out. Mr. Weiss is going to issue a report at the end. Let's let them do their jobs and stop politicizing these cases. With that, I yield back.
Gentleman yields back. Gentleman from Indiana is recognized.
Thank you, Mr. Chairman. I yield to Chairman to clear the record on some issues.
Yeah, I thank the gentleman for yielding. Just two responses to the gentleman, my friend from Maryland. He said they'll get a search warrant and go get it unless it's Hunter Biden. Then they tip off the defense counsel. We know that happened. Second, relative to Mr. Bragg. Mr. Bragg sued me, and it went to court. And guess what the court said? They said we were right, and the guy we wanted to talk to, one of his prosecutors, came here and testified in this room. So the court was on our side there. Yield back to the gentlelady from Indiana.
Would the gentlelady yield?
I need to get to my question. I'm sorry.
All right.
Attorney General, you had a very moving statement about your grandparents coming here from Belarus to live in the country without fear of prosecution. I grew up in a very similar country, Ukraine now, and when I came here as a young person, I believed in the value as an American not to be afraid of my government. But I wanted to tell you, and I want to share with you and get your thoughts on that. Are you aware that a lot of Americans are now afraid of being prosecuted by your department? Are you aware about that? Are you aware of that? I'm just saying, are you aware or not?
I think that constant attacks on the department and saying
No, it's not attacks. Well, let me give you an example.
I don't know
We talk about January 6th. People.
I'm sorry?
Here, some people came on January 6th. There probably were some people that came on January 6th here, that had bad intent. But a lot of good Americans from my district came here because they are sick and tired of this government not serving them. They came with strollers and the kids, and there was chaotic situation because the proper security wasn't provided. That's a question that was answered really why. Why we debated for 45 minutes on the floor and didn't stop the debate after the people broke into the Capitol. But these people came, they were throwing the smoke bombs into the crowd with strollers with kids. People were showed up, FBI agent to people's houses. You had in my district, in my town, FBI phone numbers all over the district. Please call that. People are truly afraid. I just want to make sure if you're not aware that you are. And this is a big problem when people are afraid of their own government. And I'll share some other things. We're talking about justice system. I don't question, you're probably not a bad person. I don't know you. But what I'll tell you, you're in charge of the department. And people right now feel, I look at Durham report and I call on the FISA violations of queries of millions of Americans, right? It's like KGB, but when I read Durham reports, we have this, you have a nice, playbook. First, let's have a special counsel, and then you don't have to answer any questions here. Then, let's extend slow walk investigation on Hillary Clinton, on Hunter. Everything is slow walk. We were very quick on Donald Trump, but you were very slow walk. Then, by the time, that investigation ended, statute of limitation expired, and all of your agents need to be tested for amnesia. No one recalls anything. Okay, you probably should have as part of your hiring policy. So no one held accountable, which was egregious what happened, in that report. When I read about them, I can't believe it happened in the United States of America. This is my frustration. I'll be honest with you. Then it's very interesting, regardless what it is, even people in Obama administration raised concerns. How can president's sons be serving on, corrupt Ukrainian oligarchs? Do you understand that it actually can undermine the one Ukrainian effort and policy? I think these concerns were raised. The Obama administration didn't do anything about it. These people are dying right now, and Americans don't trust this president. So I want to ask you one thing. I don't need answer because I know you're not going to, but I think you're probably a good American and you care. And a lot of these people are so afraid they cover up this stuff, I think, in your department because they're embarrassed that what we became as a country to say that what our Department of Justice became. That allows Russians to do propaganda in Chinese. It allows them to destabilize our country. That is danger to our republic. It is significant danger. And I have just one more question from you. I agree on corporate crimes and FISA stuff, even with Democrats, that we need to do a better job. One more question for you. Do you believe that, you talk about rights to vote, but do you believe that only U.S. citizens should be voting in this election and doing anything to make sure that only eligible people vote in elections?
Yes and yes.
Okay, I would like to see that, what you do. Thank you. Yield back.
Gentlelady yields back. The gentlelady from Vermont is recognized for her 5 minutes.
Thank you, Mr. Chair. General Garland, thanks so much for being here today. I know it's been a long day for you. Now, I'm relatively new to the committee, and I'm still getting my feet under me, but as far as I can tell, what we are doing here today is talking about a lot of conspiracy theories, and it's frustrating and tedious for those of us in the committee, but I can tell you it is absolutely maddening for my constituents back home in Vermont. We have so much important work to do to keep the government open. We're days away from a shutdown, and I just want to remind folks that we're in this situation because my colleagues across the aisle are reneging on a deal that a majority of their conference made along with their speaker. That's why we are in this situation. If they are successful in shutting down the government, seniors who rely on Social Security benefits will be impacted. Thousands of Medicare recipients and applicants will be impacted. Service members will stop receiving paychecks. Veteran services will be curtailed. Those are the grim consequences from Republicans' inability and unwillingness to govern. I needed to start with that. Let's do some level setting here. Now, let's get to the real work of the DOJ and how Congress can help the agency better serve its mission. Gun violence continues to plague our nation. We see the wreckage every day on our television sets, on our computers, and in our communities. As a member of the Gun Violence Prevention Task Force, this issue is incredibly important to me and so many of my constituents. Now, I believe there's actual room for bipartisan congressional action on gun violence, at least in some areas. One of those areas, red flag laws. It's a great place to start. Vermont is one of 21 states that was able to pass red flag laws. These laws are working to keep guns out of the hands of people who are in crisis. And yet, many states did not even apply for funding from the Bipartisan Safer Communities Act to better implement red flag laws and to raise awareness about the program. In June 2021, DOJ published model legislation to help states craft their own extreme risk protection order. Now, Republicans continue to make unfounded accusations that these laws violate civil rights by taking guns away from Americans without any due process. Can you explain the due process protections that are put into place in the model legislation that DOJ proposed?
Yes, and I would start by saying, of course, there's room for bipartisan agreement, and the Bipartisan Safer Communities Act is a very good example. And that includes the ability to have funding for states that want to craft and put into place red flag laws. The requirement is that the red flag law include due process protections. So I don't know every element of the model legislation, but the general idea is that relatives or friends of the person have to go to a court and get some kind of adjudication that the person is a danger to themselves or to others. This normally relates to mental illness problems. It may relate to some others. And so if a gun is taken away under those circumstances, there's then a right to appeal, to have a full hearing in order to adjudicate the question. That's I can't say I know every technicality, but I think that's about it.
No, I appreciate that. And it's especially important to states like mine, rural states that have real issues with the silent killers, domestic violence, and also suicide. And so these are instances in which red flag laws can really make a difference. Shifting gears here, I, along with Senator Warren and 20 of our colleagues, recently submitted a comment letter applauding the draft merger guidelines and urging agencies to finalize them. Corporate concentration remains a pressing problem for the U.S. economy, and I fear that we're falling behind in this area, and American consumers continue to feel the pain because of this. With the introduction of the draft merger guidelines, how does the department plan to ensure that future mergers and acquisitions do not stifle competition or harm consumers? Because that's often the pushback that we get.
Yeah, I think obviously the intention of the merger guidelines is to set forth the enforcement policy of the department. The different generations of the guidelines, which I hate to say it, go all the way back to the time when I was in law school, have been adopted and or been helpful to generations of judges. I've sat on at least 2 or 3 merger cases myself where we used some of the learning from the merger guidelines, and the current guidelines reflect really an adjustment to the current technology, two-sided platforms, network effects that simply did not exist at the time that the last set of merger guidelines were passed.
Thank you, Attorney General. Just briefly in closing, last year you spoke on the subject and said that DOJ's enforcement against corporate crime has waxed and waned, but it's waxing again. That is news to my ears. Thank you so much for your service. I yield back.
Lady yields back. The gentleman from Texas is recognized.
Thank you, Mr. Chairman. Mr. Garland, what is a confidential human source?
Well, it's an FBI term. I don't know all the technicality, but it's
Here, let me define it for you. It's in your own policy here. Okay. An individual who is believed to be providing useful and credible information to the FBI from any authorized information collection activity, and from whom with the FBI expects or intends to obtain additional, useful, and credible information in the future, all right? And whose identity, information, or relationship with the FBI warrants confidential handling. So these guys are individuals. You pay them $42 million a year. Did you know that? The IG said you're paying these sources $42 million a year. Did you know that?
I know informants are
It's
paid,
$42 million a year. So do you believe that they're credible, they're valuable? The FBI's using these guys. We're paying them a lot of money. Would you agree with that?
I agree. Some are more
Very
credible.
good. So they're
More
credible. You're
than
paying
others.
them a lot of money. You got a lot of them out there. So let me paint the picture for America. Hunter Biden joins Burisma in 2014. Burisma, very, very corrupt Ukrainian energy company. He has no experience in oil and gas. He admits it. He says, I don't have any experience. I know why I'm there. I have a dad. I have with me a document called the FD 1023. Have you seen this? You're familiar with it?
Yeah,
okay,
I
it's
have
used
seen
by the FBI, everybody in America. It's used by the FBI. It is a confidential human source reporting document dated June 2020. You're familiar with it. In this document, the FBI's confidential human source says Burisma, now the corrupt company, needed to keep Hunter on the board so everything would be okay. And according to the human source, they hired Hunter Biden to, quote, protect us through his dad for all kinds of problems. Mr. Garland, does that concern you? Okay, it should. I got limited time. Remember, your sources are credible, trustworthy, honest, and valuable. Are you familiar with Victor Shokin?
The document that you're...
Who is Mr. Victor Shokin? So I got 3 minutes left.
You want me to answer that?
Yeah, Victor Shokin. Who is he?
I don't know. Do you want me to
Okay,
answer
he's
the
the
first
prosecutor, folks. He's the prosecutor that was, he oversees all the corruption in Ukraine. We know there's corruption over there. For the American people watching, after a few months after Hunter Biden joined the Burisma board, Victor Shokin was named Prosecutor General for Ukraine to target corruption. And one of his investigations was into Burisma. In this FD 1023 document, the human source clarified that Burisma's CEO, the man in charge of Burisma, said he has many text messages and recordings that show he was coerced to make such payment to ensure Victor Shokin was fired. Matter of fact, there were 17 of them. Mr. Garland, it's clear Joe Biden wanted Shokin fired so he would stop looking into Burisma, where Hunter was on the board. Would you agree? All right, let's let the American people decide. Play the clip. Play the clip.
I remember going over convincing our team, or others, to convincing us that we should be providing for loan guarantees. And I went over for, I guess, the 12th, 13th time to Kyiv, and I was supposed to announce that there was another $1 billion loan guarantee. And I had gotten a commitment from Poroshenko and from
Pay attention, sir,
Yatsenyuk
please.
that they would take action against the state prosecutor, and they didn't. So they said they were walking out to press conference. I said, no, I said, we're not going to give you the $1 billion. They said, you have no authority. You're not the president. The president said. I said, call him. I said, I'm telling you, you're not getting the $1 billion. I said, you're not getting the $1 billion. I'm going to be leaving here. And I think it was, 6 hours? I looked, I said, I'm leaving in 6 hours. If the prosecutor's not fired, you're not getting the money. Oh, son of a bitch. Got fired. And they put in place someone who
There you
was
go.
solid.
Mr. Attorney General, what you just saw there was Joe Biden in his arrogance and role as the vice president in this country saying if you don't fire Shokin, the United States isn't given the $1 billion loan. Why would Joe Biden say that as the vice president? Why would he say such a thing? Was it policy? Was it our policy at the time? Yes or no? It wasn't. I have documents here. Interagency Policy Committee dated October 15th.
Point of information, is the gentleman
saying,
ever going to let the
I'm
gentleman
on my
answer a question?
time, pipe down. Saying Shokin had made
Time belongs to
significant
the gentleman
reforms.
from Texas.
He's made significant reforms, Shokin did. Matter of fact, John Kerry says he was impressive. And you know, within a few months after Shokin was fired, they appoint a prosecutor that said, we're not going to look into Burisma anymore. Cancel that, forget it, we're not looking into Burisma. Boom, here comes the $1 million. Joe Biden threatened the Ukrainian president and the prime minister, everybody can see it, to fire Shokin, or the United States won't give the $1 billion. If that is not quid pro quo, sir, what is? I will tell you what it is, and America agrees with me. It's bribery and it's impeachable. Are you going to do something about it? I bet you not, and that's why you, sir, also need to be impeached. I yield back.
Time of the gentleman has expired. The chair now recognizes the gentleman from Texas, Mr. Moran.
Attorney General, you were a line assistant U.S. attorney for years and a federal judge after that. You have significant experience with the processes surrounding criminal investigations. Tell me, what's the normal process for obtaining and executing a search warrant?
You go to a federal judge, you present an affidavit which you believe constitutes probable cause. The federal judge looks at it, makes a determination of whether it does constitute probable cause. He then signs a search warrant, and it's then executed.
And what's the purpose of a search warrant?
The purpose of a search warrant is to find to find evidence of a crime for which there has to be probable cause that it's in that location.
When executing a search warrant on a location that may contain evidence of a crime, what benefits are there for doing so without notifying the putative defendant or the target of the investigation or his attorney ahead of time that execution of the search warrant is forthcoming?
Sometimes you make notifications, sometimes you don't. If you think that the person who has the evidence of a crime is obstructing justice or is going to move the evidence or will secrete it, if you warn them in advance, then you don't give it. If you don't have those concerns, you may give advance notice.
Yeah, so in the instance of not withholding notice, you do so because sometimes they're going to actually move the evidence if you give them a heads up, correct?
It's a general hypothetical matter, yes.
And in most instances, in your experience of decades of law enforcement, have you seen that more times than not, you give a heads up to the defendant, or is it odd to give a heads up to the defendant?
I can't actually make a statistical resolution. I think it's the case that the government tries to use less intrusive methods if they can, and if they can't, use more intrusive and more emergency methods.
I agree with that, but typically when you're going to execute a search warrant, typically I think people would understand this from common knowledge, you would not actually give the heads up. Would you agree with that?
I think as a general matter, that's correct.
IRS Supervisory Special Agent Gary Shapley, one of the whistleblowers, testified that AUSA Leslie Wolf told investigators, quote, optics were a driving factor in the decision not to request a search warrant for the guest house at the Biden's Delaware residence where Hunter Biden had stayed for a time. AUSA Wolf further told the investigators that, quote, there was more than enough probable cause for the physical search warrant there, but the question was whether the juice was worth the squeeze. And she further said, quote, a lot of evidence in the investigation would be found in the guest house of former Vice President Biden, but there is no way investigators will get that approved. Now, do you agree with Ms. Wolf that optics of an investigation should be the driving factor in law enforcement decisions when investigating potential crimes?
I have to say again, as I said before, singling out assistant U.S. attorneys is a dangerous matter The supervisor of that case is Mr. Weiss. He is the one who made decisions in that case. He is the one who can answer questions as to whether those things happened or whether
So
they didn't.
let's take her out of the equation then. Let's just take the statement generally. Do you believe that optics of an investigation should be a driving factor in law enforcement decisions as to whether or not to execute a search warrant or not?
The Justice Department has standards for its work, and improper considerations are not part of those. The only questions are those driven by the facts and the law.
Mr. Shapley also testified that AUSA Wolf objected to a search warrant IRS investigators requested for a storage unit purportedly containing all the documents from the vacated office of the law firm owned by Hunter Biden. Investigators scheduled a call with U.S. Attorney Weiss, who agreed that they could search the storage unit if it remained abandoned for 30 days. But immediately after the call, investigators learned that AUSA Wolf had reached out to Hunter Biden's defense counsel to tell them about the storage unit, effectively ruining investigators' chance to access potentially critical evidence. In your experience, as you said earlier, this is not the typical thing that happens, correct?
Look, once again, I don't know anything about these allegations. I don't know whether they are correct or not. These are questions most appropriately put to Mr. Weiss at the appropriate time and to be covered in his report if he thinks that's the appropriate way to resolve.
Can you conceive of a reason why Mr. Weiss or Ms. Wolf would have given a heads up to Hunter Biden's legal team that the search of the storage unit was forthcoming?
I'm not going to get into hypotheticals about this.
For somebody that was involved in the investigation at that point, who was literally delaying obtaining potential evidence in the case, do you think it was appropriate that then she was involved in the negotiation of the IRS deal with Hunter Biden?
I'm not actually following the question. I'm assistant U.S. attorneys who participate in investigation also participate in prosecutions. Is that what you're asking?
Attorney General, I appreciate your time here today, but I'm concerned that these facts are just some examples of what's been going on here where, I apologize, I know my time's out. I yield back. Thank you for your time.
Time of the gentleman's expired. The gentleman from Maryland is recognized for unanimous consent.
Thank you, Mr. Chairman. I guess I had my 5 minutes. I would ask for the unanimous consent to offer some exhibits. First, I would offer
Without objection.
District Attorney Bragg's March 31, 2023 letter in response to the committee.
Okay.
I would offer
Objection.
the letter from Attorney Abby Lowell, Hunter Biden's attorney, to the Committee of Judiciary Oversight and Ways and Means dated September 14, 2023, and its attachments.
Without objection.
I would offer the letter from Ms. Willis to the chairman on September 7, 2023.
Without objection.
And I would offer this article from CNN, Annie Grayer, top IRS official, latest witness to dispute allegations from whistleblower on Hunter Biden tax case.
Without objection.
Thank you, Mr. Chairman.
You bet. The gentlelady from Wyoming, Ms. Hageman. We got.
We have been investigating very serious charges made about your department and other elements of the Biden administration, which allege ignoring the law to protect political allies from being held accountable for their wrongdoing. One aspect of this allegation, brought by two very credible whistleblowers from the IRS, demonstrates a strategy of delaying criminal investigation into Hunter Biden and blocking any investigations into the corruption of Joe Biden. The whistleblower testimony notes that U.S. Attorney David Weiss in November 2022 allowed the statute of limitations to expire, even though Hunter Biden's attorney had already agreed to extend the statute on the 2014 and 2015 charges, which charges included an attempt to evade or defeat taxes and the fraud and false statements related to the $1 million that Burisma paid to Hunter Biden while his father was vice president. During a recent transcribed interview with the committee, FBI officials from the Baltimore field office refused to answer questions about the expired 2014 and 2015 tax charges because they were allegedly part of a, quote, ongoing investigation. Are the tax charges related to these years, in fact, part of an ongoing investigation?
Again, I have no familiarity with the details of this particular investigation.
So you don't know one way or the other?
That's right. I left
All
it
right.
up to Mr.
So how are
Weiss.
charges for which the statute of limitations have already expired part of an ongoing investigation?
Again, I don't know anything about this case.
So why would charges that have already expired because of the statute of limitations be part of an ongoing investigation?
To answer in the hypothetical, because I don't know the facts, often charges from previous times are used as part of an ongoing investigation to inform information about intent, about patterns and
Or
practices.
other investigations? So are there other investigations into Hunter Biden where this information may become relevant?
I think it's a matter of public record that there is a tax investigation of Mr. Hunter Biden with respect to other years. I don't
Beyond the
think that's
2014 and 2015?
beyond the ones that are that you were referring to. I think
Okay, Mr. Garland.
Mr. Weiss has already said that during the plea proceeding.
Okay, Mr. Garland, is it standard operating procedure in your Department of Justice for prosecutors to allow the statute of limitations to expire on very serious crimes when the potential defendant has already agreed to an extension?
So there, as I said before, there's no standard operating procedure
Okay.
here. This is
Maybe there should be.
Well,
If this is an oversight hearing, maybe there should be. Maybe you should adopt standard operating procedures to avoid this kind of a circumstance. Would you agree?
no.
Okay.
Because it's left
According
to
to
the
one of the
discretion
IRS,
of
you've answered my question, thank you. According to one of the IRS whistleblowers, quote, the purposeful exclusion of the 2014 and 2015 tax years sanitized the most substantive criminal conduct and concealed material facts, end quote. How can Americans trust an investigation run by a special counsel who, by allowing the statute of limitations to expire, irreversibly, quote, sanitized the most substantive criminal conduct and concealed material facts?
the prosecutor in question is an experienced veteran career prosecutor who was appointed by
And we have no reason to trust him, do we?
by President Trump.
Okay. How much in terms of taxes would Hunter Biden have owed on the $1 million he was paid by Burisma?
Well, as you can imagine, since I don't know anything about the facts of the case, I can't answer
Probably
that
about
question.
$400,000. Isn't that right? I mean, you can do the math. You know the tax code.
I don't know anything about the facts of this case, so I'm not able to do the math to apply it to
And by
facts I
failing to
don't know.
pay the taxes on those ill-gotten gains, what would the typical penalty have been, for example, if it was someone who didn't have the last name of Biden or a D behind their name?
I'm sorry. These are all questions you'll have to direct to Mr. Weiss, and that Mr. Weiss will address in his final.
By allowing the statute of limitations to lapse, did Mr. Weiss effectively gift the tax money Hunter Biden owed for the 2014 and 2015 tax years to Mr. Biden?
To say again, the decisions about whether in this area and whether these allegations are correct are ones that Mr. Weiss will be able to answer.
Mr. Garland, one of the things you have done over and repeated over and over and over again is that to point out that Mr. Weiss was appointed as U.S. Attorney by President Trump, as though that somehow inoculates him from criticism by us. Is that really how this game is played? That if someone is appointed by a Republican, then they're supposed to be on the Republican team? Or if they're appointed by a Democrat, they're on the Democrat team? You were appointed by Mr. Biden, weren't you? Are you on the Democrat team?
Let me just be clear. The point of that he was appointed by a Republican counteracts the claim that this was a partisan decision to benefit Democrats.
He remained as a member of the Department of Justice.
Mr. Chairman,
under you.
Mr. Chairman.
Time of the gentlelady has expired. The gentleman from Maryland is recognized again for a unanimous consent request.
Thank you, Mr. Chairman. I want to offer into evidence the testimony, or segments of the testimony of Thomas Sobocinski, dated September 7th. It was taken here and before this committee. Goes to the deconfliction issue with respect to Hunter Biden's security detail and the search warrant
Without objection.
executors. Thank you.
Chair now recognizes the gentleman from California.
Good afternoon, Mr. Attorney General. Do you believe Christopher Wray is a competent director of the FBI?
I think Mr. Wray is a person of the highest integrity, for whom I have great admiration, who has extraordinary experience, both as
Thank
a
you.
career
And so you
prosecutor.
certainly don't think he would knowingly give false testimony to this committee, do you?
I am sure that he would not.
Are you aware that Director Wray a couple months ago in sworn testimony implicated you in a sweeping abuse of power?
I doubt he would characterize whatever he said in that way.
Well, he testified about the school board memo that you issued on October 4th of 2021, in which you mobilized federal law enforcement powers against American parents. Now, of course, you didn't put it quite like that. Instead, you found a pretext, which is stated right here in the first line of the memo. In recent months, there has been a disturbing spike in harassment, intimidation, and threats of violence against school administrators, board members, teachers, and staff. What was your basis for making that claim?
I will say again, as I've testified numerous times in response to exactly the same question, that I saw numerous reports in the press of violence and threats.
You saw reports in the press, and so you decided to instigate a nationwide law enforcement initiative?
If I may be permitted to answer the question.
Please.
Numerous reports in the media of violence and threats of violence against school personnel of all kinds.
Did you consult with the FBI director?
We received a letter from the National Association of School Boards reporting.
Yes, that letter contained anecdotes. It didn't contain data of an increase. Did you, yes or no, consult with the FBI director before issuing the memo?
I don't believe I spoke with the FBI director, no.
Why not? Why wouldn't you consult with the FBI director?
Because the purpose of the memo, as is very clear from the memo, is to ask the FBI to assess the situation, to hold meetings, and to determine whether this was...
Mr. Attorney General, you started with a conclusion that there was an increase in threats. Now, if you had bothered to consult with the FBI director, here's what he would have said. This is from his sworn testimony, that he was not aware of any such evidence. So my question to you, sir, sitting here today, is can you substantiate your claim that there was an increase? Of course, there will always be sporadic criminal activity in all quarters of society, but your claim was there was an increase. Can you substantiate that sitting here today?
I can substantiate that by the reports in the press of violence and threats of violence and by the letters sent by representatives of thousands.
That's a no. You're giving us anecdotes. I'm asking you if you had data. You also said in your memo that you were committed to using the department's authority and resources to discourage these threats, identify them when they occur, and prosecute them when appropriate. Were there any such prosecutions?
The emphasis should be there on when appropriate, and there were no such prosecutions, and that's good news, not bad news.
There were no prosecutions, and in fact, Director Wray said there were no arrests, there were no charges. So you have no data to show us that there was any increase. You didn't even bother to consult with the FBI director, and then there were no resulting prosecutions, even though you said that they were coming. So I have to ask you now, in retrospect, was there a compelling law enforcement justification for the memo?
I think you're mischaracterizing the memo. The purpose of the memo was to hold meetings, to open lines of communication with state.
So is that a no? Yes or no? Was there a compelling law enforcement justification for the memo?
I believe there was a reason to ask for those contacts to be made with state and local law enforcement.
Well, the FBI director disagrees with you.
That's not what the FBI director said.
Look at it right here, Mr. Attorney General. When asked, do you have any reason to dispute the conclusion that there was no nationwide law enforcement justification? He said he didn't.
Either he didn't see the reports or he didn't see the National
This is a transcript. I've sent you this transcript, Mr. Attorney General. So my question is this. Will you retract the memo, and by that I mean issue a formal document to the effect that it is no longer operative?
I will not, because there was absolutely nothing wrong with the memo, as I have testified several times already.
Even though your own FBI director says there was no justification for it, you will not retract it?
The memo is mine. It's my decision whether it's necessary to make assessments like this, and I asked the Bureau to make these assessments, and the other...
Are you familiar with the concept of a chilling effect?
I'm sorry, I didn't...
Are you familiar with the concept of a chilling effect?
I'm very familiar, and that's the very reason...
How would you define a chilling effect as it relates to First Amendment jurisprudence?
That's the very reason why the second sentence of the memo says...
Please tell me what you consider to be the definition of a chilling effect.
That memo has no chilling effect.
I didn't ask you your opinion on whether the memo has one. I asked you what is a chilling effect.
I'm telling you that the second sentence of that makes clear...
I've read the full memo. I'm asking you, what do you define a chilling effect as?
A chilling effect is when people's exercise of First Amendment rights are chilled by coercive activity by the government, which did not occur here.
So here we're dealing with moms and dads.
Mr. Chairman,
You and I
point
are
of order
officials.
with respect to the time.
Yeah.
Point of order.
that the gentleman's time has expired, but it was a pretty darn important question when the Attorney General of the United States can't define what a chilling effect is, so I thought I would let it go a few seconds.
The Attorney General did define what a chilling effect is and said it didn't occur here.
I don't think he defined it, he just dismissed it. The gentleman's time has expired. I thought it was a very important 5 minutes. We now recognize the gentlelady from Florida for 5 minutes.
Good afternoon, Mr. Attorney General.
afternoon.
I'd like to return to the earlier discussion about FISA process and the FISC. A number of the members of this committee and of my community are gravely concerned about the well-documented abuses of the FISA process and within the FISC proceedings. In declassified opinions from the FISC in 2018 and 2019, the presiding Judge Boasberg admonished the FBI, stating there still appears to be widespread violations of the querying standard by the FBI, and that there appears to be a fundamental misunderstanding of some FBI personnel about what the standard reasonably likely to return foreign intelligence information means. Mr. Attorney General, what measures has the FBI instituted since that time to ensure that these abuses are stopped?
So we're talking about FBI FISA Section 702.
Yes, sir.
Which is a central part of our ability to find out what foreign nation states, foreign terrorists are trying to do in the United States. When I first came into the Justice Department as Attorney General, I read the opinions you talked about, and they deeply concerned me. And I agreed when I looked into it that there was a misunderstanding by operators and analysts as to what the query standard were. So one of the very first things I did was send a memo to the FBI directing that the way in which the Justice Department, and particularly the FBI, did the querying be examined and that corrections be made. This was an extension of a memorandum that Attorney General Barr had likewise, after he read similar concerns, sent to the FBI at the end of 2020.
And Mr. Attorney General, in addition to other things, the ultimate adjustments included additional attorney oversight, requiring FBI users to affirmatively opt in to search the 702 database, updated guidance and training, and enhanced approval requirements, correct?
Yes, ma'am. All that's true, and the consequence was a 93% drop in the number of U.S. person queries.
Nonetheless, Mr. Attorney General, you would agree, would you not, that there are continued needs to review, analyze, and make additional improvements and safeguards to ensure that we don't continue seeing these abuses?
I do agree.
In fact, in recent weeks, we saw even President Biden's Intelligence Advisory Board make recommendations that we continue to revise 702 oversight and restrictions, including a recommendation to direct the DNI and the Attorney General to research potential technological enhancement to the current oversight framework. Tell me, what technology might modernize and improve oversight of the 702 process?
One of the technologies that has already worked very effectively is to change this from an opt-out to an opt-in set of queries. So you have to, first of all, indicate that you are looking at 702 and not just across the board of the FBI holdings. You have to have a drop-down window which explains why you are going to do this. It's easy for us.
Does that window require the user to input narrative text?
That's right. That's right.
All right. Thank you, Mr. Attorney General. Are there other technology-specific changes that you would recommend?
Well, I'd like to consider that more. There are various kinds of auditing programs using technology. The National Security Division, Justice Department has done some of that. The FBI, actually at the request of Attorney General Barr, began an auditing program like that. FBI Director Wray, who also agrees that these kind of non-compliance shouldn't continue, put that auditing program into effect within the Justice Department.
Thank you, Mr. Attorney General. I yield the balance of my time to the chairman.
Gentlelady for yielding. Mr. Garland, in David Weiss's letter to Senator Graham on July 10th of this year, he says this: I was assured that I would be granted special counsel authority if it proved necessary. And this assurance came months before the October 7th, 2022 meeting referenced throughout the whistleblower's, allegations. How was that assurance given and who gave it?
I'm sorry, I think he was talking about 515 authority. Is that what I'm reading the letter now. He's not talking about special counsel authority. It says that I was assured.
515 authority, okay.
Yeah.
Same difference.
Yeah.
Well, not same difference, but same fundamental question.
I understand your point, yeah.
He's making the point that he was assured that this was, he could get this status, and that status came, that assurance, excuse me, came before October 7th, 2022. How was that assurance given and who gave it?
Yeah, I made that clear in my direction, and that was transmitted to him.
So you told him that
No,
back before October 7th that
I'm
he
not
would
gonna,
have?
I'm not going to get into exactly the deliberation of the department, but I
There's
gave,
three simple questions. How was it given? Who gave it? When was it done?
yeah, I understand. I gave a direction from the beginning that he would be able to bring a case whenever, wherever he wanted to. That direction he heard, obviously, and he confirms that here.
I went a little over time, so I told the ranking member I'd extend to him a few seconds or minutes if he wanted to say a few more things or ask a few more questions, and then we'll.
Thank you. Let me just ask the Attorney General. Mr. Attorney General, you've been asked many questions here which you were not permitted to answer. People asked the question and just asked another question, didn't permit you to answer. Is there anything you'd like to say in answer to anything that you think should be made clear or added?
Look, I'm grateful for the opportunity. I just, again, I want to assure the American public and this committee that the Justice Department follows the rule of law. It enforces the law equally without regard to persons and without regard to parties, and that we do the best we can to follow the facts and the law.
Thank you.
Mr. Attorney General, we appreciate you being here, and the committee maybe have to do something official. I guess anyone who wants to add something to it, they can submit that for the record. With that, the committee is adjourned.
Thank you.